the grand challenge. Now we have a grand challenge to work towards. So our next speaker is Alexandra Wood. She's a visiting professor at Purdue University on AI policy and society. She's going to bring us some legal perspectives on applying DP for health.
Thank you very much. It's a pleasure to be here. I'd like to offer a legal perspective on the use of differential privacy for biomedical data sharing. This talk focuses on a problem that arises from the dual mandate of federal research agencies, including NIH. It's longstanding policy of NIH to promote the broad sharing of research data. It's recognized as essential to enabling the translation of research into knowledge, products, and procedures that improve human health. But at the same time, the sharing of scientific data must be consistent with protecting research participant privacy. And these two obligations are inherently in tension because sharing human subjects' data always carries some risk to privacy, and these risks are growing as research continually exposes new data privacy vulnerabilities. And this problem is illustrated by NIH's shift in policy with respect to genomic research databases. As a brief recap, I'll explain that in 2007, NIH issued a policy for sharing data generated through NIH-supported genome-wide association studies and launched the database of genotypes and phenotypes, or dbGaP. Genomic summary results were originally made available through dbGaP's unrestricted access tier. And then in 2008, research by Homer et al. Demonstrated a membership inference attack that would enable an adversary to leverage an individual's whole genome information to confirm the presence of an individual in an aggregated genomic data set, potentially exposing that individual's association with research on a particular disease, for example. In response, NIH reclassified genomic summary results as controlled access data. And then from 2008 to 2017, NIH reviewed this decision, holding a series of workshops and publishing requests for information, seeking feedback from stakeholders on how to balance risk and benefit when sharing genomic summary results. And the conclusion was that the response largely supported wider access to genomic summary results, viewed the benefits as greatly outweighing the risks, and in particular, they noted that allowing wider access to genomic summary results would reduce requests for individual-level data and in turn reduce privacy risks overall. And in 2018, NIH updated the access model for genomic summary results, providing that most would be made available under the unrestricted access tier once again. And institutions can, on a case-by-case basis, designate a data set as sensitive, thereby enabling controlled access rather than unrestricted access. And I think this case demonstrates that there's a disagreement between technical and normative understandings of privacy, and there's a lack of a coherent framework for making real-world decisions at this intersection. And in joint work with Kobe Nissim, we've identified specific gaps between technical and normative understandings, each of which contributes to the challenges presented in this real-world case. The first gap is with respect to the generality of protection afforded. In 2007, genomic summary results fell outside the scope of the types of information traditionally considered to be identifiable, and therefore received no protection. This approach stands in contrast to formal privacy models like differential privacy, which protect all information specific to an individual, regardless of what category it falls into. And the second gap is with respect to the scope of attacks contemplated. The NIH genomic data sharing policy requires investigators to strip human genomic data of the 18 identifiers specified by HIPAA in the privacy rules safe harbor method for de-identifying protected health records. And this approach is designed to protect against record linkage attacks based on information that's readily linked to auxiliary data sets like public records. But this approach provides little protection against other types of privacy attacks, such as the membership inference attack we saw in this case. And further, stripping identifiers has been shown to fail to protect privacy, as any information about individuals has the potential to leak information specific to individuals. And so this expectation that data can be shared on an unrestricted basis once the 18 identifiers are removed is out of step with the scientific understanding of privacy. And we also see that there's an instability in the standard in this case. What's considered safe to share shifts over time depending on the discovery of new types of attacks or due to the expanded availability of auxiliary data sets that could be leveraged in an attack. And this case raises questions with respect to the relationship between privacy definitions and underlying normative expectations. So there may be cases where the utility requirements of a data user community, such as researchers who may need to be able to study rare outlier cases in a biomedical data set, would require a differentially private implementation with privacy parameters that would allow a significant leakage of personal information. Or, on the other side, if a research subject's expectation of privacy extends beyond the individual to their biological relatives or to the larger homogeneous subpopulation, accounting for this would require parameters that would reduce utility significantly. And if we look at the NIH genomic data sharing policy, we see it explicitly recognizes that the risk of re-identification with respect to genomic data is increasing over time. And it also acknowledges that despite being de-identified in accordance with the common rule and the HIPAA privacy rule, the genomic data held in dbGaP can be re-identified. And for this reason, NIH has obtained a certificate of confidentiality for dbGaP as an additional precaution, and investigators of NIH-funded research that collects or uses identifiable sensitive information are automatically issued certificates of confidentiality as well. And the NIH policy for data management and sharing notes that investigators should consider whether data should be shared using controlled access rather than unrestricted access, even in cases where the data have been de-identified. It also provides that NIH may support the development of resources to assist researchers and institutions in determining how to appropriately de-identify data from human subjects. So in other words, NIH policy recognizes that traditional approaches to de-identification are inadequate for genomic data, that additional controls may be necessary, and that new resources to guide effective de-identification are needed. And I'd like to suggest some principles that NIH policy and resources could be developed based around, or that the data management practices of investigators could be evaluated against or updated in accordance with, in line with a modern understanding of privacy. These principles were developed by a working group of computer scientists, information scientists, and legal scholars, and they're designed to address the gaps between technical and normative approaches to privacy that I highlighted earlier in the talk. The first principle is the process protection principle, which means that data protection should be evaluated based on how the data is processed, not based on the results of the removed. Rather, what matters is how the data set was generated, because privacy is a property of that analysis, not its output. The next principle, the inclusion-based protection principle, defines identifiability in terms of what you can learn about an individual as a result of the inclusion of their information in this. And this recognizes that learning general statistical relationships about populations, for example, that there's a relationship between smoking and cancer, is unavoidable in the era of big data and artificial intelligence. And in fact, this type of learning is the objective of biomedical data analysis. The next principle is the format neutrality principle. It recognizes that a data release should not be treated differently, whether it takes the form of a summary table, statistical model coefficients, or a trained model output. In many cases, outputs can be transformed from one format to another with little or no loss of information, and so simple reformatting may make some information less readily apparent. It should not be considered protective. And the composition awareness principle recognizes that any analysis or release of information carries disclosure risk, and this risk accumulates with each analysis or release. Therefore, a release cannot be described as protective or not protective, rather it falls along a continuum. The next principle recognizes that rather than assuming a narrow set of potential attacks and attackers, it's necessary to adopt a wide conception of potential attack modes to ensure robust privacy protection. And the final principle recognizes that the security of a system should not rely on the secrecy of its mechanisms. Systems should use public algorithms and protocols built and vetted by the security community. And I'll end on these recommendations. More work will be needed to apply these principles to the development of detailed resources to guide the data privacy management practices of biomedical researchers. But it's my hope that this framework can serve as a useful bridge between the technical and normative understandings of privacy in support of this line of work. Thank you.
Questions? No? Okay. Yeah, Salil.
So Alex, going to the NIH sort of history, the history with dbGaP and kind of where they ended up, it's striking the sort of discrepancy between the sort of current policy and the recognition of the risks. And do you have a sense from your study of that case study that this is viewed as a temporary compromise because there's not a readily available good solution for reconciling the need for making data available? Is it too much pressure from the data user community to remove barriers to data access? Or a implicit sense that, well, the privacy concerns aren't serious enough to outweigh the benefits of making the data available?
I think it's primarily that they didn't see the privacy risk as being very significant in the overall scheme of privacy violations. And they also viewed the benefits to so overwhelm the risks in that case, that researchers were trying to gain access to the data and they were facing all of these barriers in getting access to the individual level data, and it ended up making this data more widely available and for research discoveries to be made, and that was viewed as so important that it outweighed any other concerns with respect to membership inference attacks.
Thank you.